Good morning, good afternoon, good everything. My name is Jason Weiss. I am here today at the Ask Jason Weiss show, where I am here as a legal consultant and a legal coach. Although I am an attorney, I am not here as an attorney today, and nothing on this show is meant to be legal advice. No attorney-client privilege is created here. No attorney-client relationship is created here. And the same applies for my wonderful guest today, Rick Gaines, who is a matrimony and family law attorney. And we are going to be speaking with him about the ins and outs of family law. So I'd like to introduce Rick Gaines. Rick, you there?
I'm here. Good afternoon, everybody.
How are you doing?
Doing great. Thank you.
So thank you so much for being on the show today. And today we're going to talk a little bit about family law, the ins and outs. And you know, what does that mean? I don't know. I made up the title. I did it on a whim. But I figured that a lot of the listeners today are here because of the going solo media, which means that they are contemplating going solo either professionally or personally, or they have just recently gone solo professionally or personally. And I thought it would be a great opportunity for someone who practices in that area in both family and corporate law. I can't forget the corporate law part. So Rick, I'm going to cut you off at like 30 seconds, 60 seconds, but just tell us a little bit about yourself, your practice, and how people can get in contact with you.
Sure. So professionally, my name is Richard Gaines. I'm an attorney, been practicing 26 years this month. I'm starting my 27th year. I engage in the practice of family, matrimonial, and divorce law, as well as commercial and contract-related litigation. My office is in Coral Springs at the Coral Springs Professional Campus, located at 5531 North University Drive, Suite 103. And my office telephone number is 954-603-8801. And if you call, you'll get to speak to my delightful legal assistant, Barb.
And I know Barb, and she's great. So props up to Barb and to Rick. So I guess I'm going to ask the question, how is it that you found that little niche or area together where it's family law and corporate law? Because most of the time, it's funny. People will say to me, well, what areas of law do you do, Jason? And in my prior life, when all I did was practice law, I would say anything but family and criminal, because I think they're one and the same. Ha, ha, ha. It was an icebreaker. But I think you found a very unique niche where it's family and corporate. Explain how maybe those two go together and how you might be able to, help people better or understand more, or heck, maybe even save them time and money by them coming to one place where you are.
Sure. So just to clarify, it's not corporate law, it's commercial litigation. And commercial litigation, at least the way that I define it, is any dispute that centers around a contractual or a business relationship. It could be, for instance, in the context of family, the contractual relationship could be between the husband and wife, and we're working on a marital settlement agreement or some type of settlement document. In more of the commercial world, it could be a landlord-tenant dispute. It could be a business dispute between two corporations where they're fighting about a breach of contract situation or a fraud situation. As a young attorney, I essentially was raised practicing exclusively in the area of commercial and contract-related litigation. And as I started to develop my practice grew to include family, matrimonial, and divorce law. And now primarily what I do is family related. About 70% of what I do is family related. The remainder is commercial contract related. And the intersection between them, which I found to be very helpful, is for one thing, again, when you're resolving family matters, whether it's a divorce case, it could be a domestic violence case, it could be doing a prenuptial agreement, you're dealing with drafting contracts, and there's certainly, I perceive an advantage when drafting contracts, in that case, settlement agreements, as also knowing what people typically fight about in the context of a commercial litigation. So having the benefit and the experience of fighting about things when people's contractual relationships go awry It's been very helpful to my family-related practice because when I'm putting together settlement documents or otherwise resolving cases, I have the experience of knowing what types of things need to go into a well-written document to give my clients the maximum level of protection for the terms that they negotiate.
And I think it would also come into, be beneficial and come into play because we hear about it more and more, husband and wife, husband and husband, wife and wife, spouse and spouse, owning a business together. And when they do separate their marriage, what do you do with the business? How do you operate the business? What do you do? I mean, I know you've dealt with that before. Is that something you can handle as well as part of the attorney?
So oftentimes what we do if we're dealing with separating corporations is the marital settlement agreement, for example, would have very clear and well-written provisions on who is going to keep the business or how the business is going to be operated going forward. Part of my practice, I don't draft the corporate documents like shareholder agreements. Those are often already in place. If the corporation is a significant corporation with multiple owners, if it's a small corporation typically owned by only a husband or wife, there may not be shareholder agreements or operating agreements, in which case I would refer to specifically a corporate lawyer who doesn't engage in litigation, but he drafts those types of corporate records. But yes, from litigating those issues and litigating disputes between business entities or business partners, it does help to inform how to draft a marital settlement agreement or some type of a family resolution document to provide for those provisions. In my broad-based family practice, part of my family practice includes probate, trust, and guardianship litigation. And so not just in the context of divorces, but in the context of when you're dealing with the passing of a loved one, oftentimes family members are fighting about what happens to the estate, the distributions, and it's certainly helpful to understand how to draft documents to deal with distribution of corporate assets or otherwise to include provisions to make sure that those are adequately conveyed.
So I'm gonna ask you a question now, and and I know we didn't script anything. So if this is a question that throws you off, you can punch me later in the arm, not in the face. How do you handle the very difficult discussion with a client that comes to you, Rick, I'm getting married, I'm so excited, he's the love of my life, she's the love of my life, whatever it is, but he or she asked me to sign a prenup. I don't want to do that. I don't want to go into a marriage thinking my marriage is going to fail. Like, isn't that setting me up for failure? How do you deal with that? How do you tell your client that, look, a prenup, if you're wealthy, if you've got things, is phenomenal for you, or or your potential spouse, look, he or she is trying to protect their money. How do you have that what I perceive as a very difficult conversation?
Sure. So it's a loaded question, and as difficult of a conversation as it is between attorney and client, imagine how difficult it is when you're either the soon-to-be or prospective husband or the prospective wife, and you need to ask your betrothed to sign a prenuptial agreement just in case things don't work out. It's really one of the most difficult and emotional issues I deal with, and the way I deal with it really depends on who's calling me. It's not a matter of husband or wife. It's a matter of who's the one with the money or the income or the asset that needs to be protected. So let's say I'm dealing with the moneyed person, the person who's looking to protect assets and liabilities. One of the first things I say is if there's an issue on the other side, you need to seriously think about whether this is a relationship you want to get into. Are you are you in the relationship because your partner wants to be with you for financial reasons? That's kind of as far as I go, because my job is not to counsel and advise anybody whether they should get married or should not get married, but I always raise that as a question. In first marriages, if it's a young couple, they don't have many assets, they're intending to have children together. If one person is asking for a prenuptial agreement, it raises a lot of red flags. One, what are the doubts that this person has about the prospective relationship? And two, why is that person looking to protect potentially assets and income that are going to be developed together during the lives of a young and growing couple who are intending to raise a family together? To me, that raises a lot of questions. if the person coming to me is the person who asked the question, I really ask that person to explore, why are you doing this? Is it because you're really concerned that the marriage isn't going to work out? Are you expecting to inherit money? Are you expecting to develop significant sources of income? And why are you trying to protect the assets? If it's, for instance, a young, the young other person, maybe it's the wife or prospective wife coming to me and says, we're young, we're going to have children together, I don't work, my husband owns multiple businesses, or he's a businessman, he wants me to sign an agreement and waive alimony and waive my right to share in marital assets. Again, I'm going to ask the same questions. What is he seeing in the relationship that you're not seeing? Because you're going to be destroyed if you enter into this type of agreement. Where does a prenup really make sense, or even a postnup? Sometimes second marriages, third marriages, even fourth marriages. We have lots of them here in South Florida, especially in our community, Parkland, Coral Springs, Boca Raton, in the more, upper middle class communities where people have money. But the second and third or subsequent marriages where there's already children. Where the soon-to-be spouse has children that they want to protect assets for as an inheritance, where they already have established businesses. Maybe they're already paying spousal support or alimony to a prior spouse, and maybe both parties are coming into the relationship with some significant sources of income, assets, and maybe even liabilities that they want to be able to protect. They want to have a loving relationship together, but they want to separate the financial aspects from that relationship so that they can each maintain their estate for their children, for their intended heirs, and essentially just enjoy their lives together, but keep their finances separate. I always find that a prenuptial agreement makes more sense in that type of situation than it does for a young couple that's intending to have children together and start their lives together.
Now, you mentioned something during your explanation that you mentioned a prenup, which I think is common and everybody knows what a prenup is. But you mentioned, a trust and a will and all of that. And I think the norm knows that. But you mentioned something called a postnuptial agreement. I'm going to admit, I really don't know what it is. So if I don't know what it is, there's a good chance somebody listening here doesn't know what it is either. What is a postnuptial agreement?
So a postnuptial agreement or a postnup is the same as a prenuptial agreement, except it's done during the marriage. So before the marriage, post, after the marriage. And a marital settlement agreement that parties draft as part of a divorce is a type of postnuptial agreement, but a more specialized postnuptial agreement might be done in a situation, for instance, if husband and wife are not really getting along. They love each other, they maybe have children together, and they can get along really well on everything, but their finances are a mess. Maybe one of them is financially irresponsible, and the parties think that their relationship would have a much better chance of continuing successfully if they just take the financial issues out of their relationship. So they might do a postnuptial agreement, provide for what alimony might be in the event of a divorce, separate their assets, separate their liabilities, make provision for the payment of ongoing expenses, and then they can just enjoy their lives because they don't have the pressure of the financial responsibilities or concern about the other spouse's financial impropriety because they've already separated out their financial responsibilities to each other.
So one of the other things that you talked about was the will and estate planning documents. When do you recommend that somebody contact you or another attorney and get their estate planning documents in place? Is there a specific time? Is there an age? Is there a marital status? What do you recommend? I know before death would be nice, but
before death it would definitely be helpful. So yeah. I would say if you have total assets or a total estate that's worth at least $1 million, you need to have some type of estate planning in place, at the very least a will. If you have minor children and you have an estate, then you should absolutely have some type of estate planning in place. I generally recommend that if people have, an estate $500,000 or more and minor children, that they should go to a certified estate and trust lawyer, have a trust prepared for the benefit of children. So in case the parents both die and there's still minor children, that money is protected for the children. You don't have to go through a guardianship process, which is very time consuming and expensive. And generally for some people, once you get married, even if you don't have children yet, some people like to have a will in place. So if I die, everything goes to my wife. If my wife dies, everything goes to me. And then you can update that over the years as you either have children, as your estate increases, and as more specialized needs arise.
And I'm assuming that there's certain potential tax benefits to the living spouse, or certain loopholes or certain hoops you don't have to jump through, and by having everything prepared ahead of time.
So it depends on the level of your estate, and this is outside my area of expertise, which is why at a certain level I recommend that my clients speak to a certified trust and estate lawyer. But there is a level of your estate where it becomes taxable as estate and gift tax, and there are provisions that people need to be aware of with respect to disposition of their assets on their death that have tax implications. But generally, during a husband and wife, if the husband, for instance, leaves everything to the wife on his death, or if assets are jointly titled, my understanding is that those are not taxed so long as the estate is below the certain tax gift, the estate and gift tax levels. But again, that's outside of my area of expertise.
Right. And we're not giving legal advice here. We're not tax attorneys, but it sounds like that the idea is, look, speak openly, speak with your spouse, speak with your partner, speak with your family, make sure everything is there. If you have questions, go see a tax attorney. There are plenty of them out there, and they love what they do, and they will help you avoid those tax implications.
Yeah, what I do try to do as part of my broad-based family practice is I'm always, open to having the discussions, about my clients or prospective clients' needs, but I'm not looking to take every possible piece of business that comes my way. I know what I'm very capable of handling, and that's within the confines of my family practice and my commercial litigation practice. And if I have a consultation or somebody calls me up and they're looking for something outside my area of expertise, then at that point, I do look to refer to very capable attorneys who I know and have a relationship with to make sure that the client has the best representation possible.
Wait. There's an attorney out there that doesn't know everything? Oh my God. I mean, this is crazy. No, that's great. And, we've worked together on some files, and we'll continue to work together on files. And, just take, the one thing I remember from family law, whatever's in the best interest of the child. That's the one thing that I remember from my one family law class in law school.
That's one of the most important principles we have.
Yep. And I'm sure you have to remind clients and opposing counsels and fighting spouses and business owners. Remember, you got to look out for the best interest of your kids.
Yeah, it comes up in any disputed case where there's children, and the difficult thing about that is both parents, or each parent, often has a different perception of what's in the best interest of the children, because their perception is that the best interests of the children align with their own personal interests, and that's where cases often get disputed and ugly.
Yeah, and I'm sure there's been times where maybe your client and your personal beliefs as to what is the best interest of the child doesn't relate, and sometimes you have to say to your client, "Hey, look, he or she kind of agree with that." I mean, that's got to be messy, huh?
So I do try to keep my personal beliefs out of it, but I'm not an attorney that practices from the perspective of I tell my clients what they want to hear. I'm no yes man. I take very seriously my role as counselor and advisor, and make sure that my clients hear what they need to hear, because they're paying a lot of money for legal advice. I'm not necessarily the warm and fuzzy type. I'm more along the lines of if objectively you're off your rocker, I'm going to let you know. And then at that point, if it's legal and ethical and you want to pay me to fight about it, sure, that's what I'm here for. But I do go through that process of counseling, advising, and making sure that my clients understand the implications of the decisions that they make or that they're thinking about making, so that they can make the best decisions for themselves.
So, Rick, what we're going to do now is we're going to take a quick break. A commercial is going to run, and then we're going to get back. And I think maybe I'd love to talk to you a little bit about how has COVID affected the family law courts, the family law situation, marriages as a whole, fighting among spouses, recommendations. So we'll touch on that in a minute. Cece, I know you got a commercial from one of our great sponsors today, so roll it out. So we are back and want to say thank you to our sponsors and the commercials, and we appreciate everything that you do. I'm here with Richard Gaines, who is a family, matrimonial, and litigation corporate attorney who's actually here, who's actually here with me in Coral Springs, Florida. And before the break, I threw out a little bit of a teaser that I wanted to talk about what everybody seems to be talking about these days and has been talking about nonstop for 18 months now, COVID. So how have you seen COVID have an impact on, and you can take your pick, you can do one at a time, but relationships, divorce, court proceedings in that realm? I guess let's start with relationships and divorce. Have you seen a change in people due to COVID?
So I can't necessarily say if I see it due to COVID, but it's been, over the last year and a half, cases seem to be getting more difficult. People seem to be more emotional. The level of craziness within the context of ongoing divorce cases seems to be elevated. Some of that I just attribute to where, we live in Florida. And, but, some of it could certainly be, a result of the stress that people are suffering because of the lack of employment, health-related issues. Certainly, I've had a number of clients who have lost family members and loved ones to the virus. So that can be some of the issues. Sadly, at least in South Florida, divorces and family practice is always busy. It's always an ongoing issue in South Florida. So I don't know that I can tangibly tie the divorce rate or the amount of ongoing litigation and family related disputes to COVID, because as I said, it's always at an elevated state in South Florida, especially. So the real impact of COVID, at least from the family practitioner perspective, has been in the court system and the way that we essentially do our work, these days. So customarily, if there is a hearing, whether it's a 5-minute legal argument, which we call motion calendar, or if it's a short evidentiary hearing, an hour-long hearing, a 2-hour hearing where there's evidence presented and parties testify, or even a full-blown trial. We used to do those things live. We'd go to court, we'd present witnesses, everybody has to drive down to the courthouse. It was a whole big ordeal. Now everything is done by Zoom. Any short hearings, as I said, motion calendars, 1 or 2 hour special set evidentiary hearings, and even multi-day trials, we do them all electronically by Zoom. It's been challenging to do those because you don't get the benefit of, as an attorney, one of the things that we really focus on, especially in a contested case, is you want to make the other side look bad as a witness. And you also want to be able to read their body language and their facial expressions, and you want the judge to be able to see that. We lose a lot of that ability over Zoom because we don't have the personal nature. So sometimes we can get it, but it's certainly not the same as being live. But we are able to do and conduct proceedings by Zoom, and cases are going forward, so cases are being resolved. But there's certainly some level of difficulty. Oftentimes, even today, a year and a half into this, people have technical issues. So if you have 1 hour reserved for a hearing, but somebody's Zoom isn't working, their internet shuts down, lots of times the courthouse gets shut down, the judge's system is lost, and you can't finish your hearing, or we can't finish our hearings. We've got to wait oftentimes months to get things reset because there's a huge backlog of cases in all of the South Florida counties, whether it's Palm Beach, Broward, Miami-Dade County. On top of that, depositions are normally live. Mediations, which are settlement conferences, are normally live, but substantially now they're all taking place by Zoom, which again, it's great that we have the tool and we can continue to move cases forward, but we lose that personal touch. We lose that ability to be face-to-face with somebody, to be able to evaluate their body language, their facial expressions. And frankly, there's, at least from an attorney's perspective, there's some element of wanting to be able to intimidate or impose yourself and your strategies, and not physically intimidate, not physically threaten, but, through the job that you're doing, be able to intimidate and break down the other party as a witness, to advantage your own client. And to a large extent, through media, we don't have as great of an ability to do that. Sometimes we can do it. I would say generally it's not as effective. Mediations or formal settlement conferences where there's a mediator whose job is designed to help bring the parties to settlement. The mediator has no power. In a Zoom mediation, the mediator sets up separate rooms, and the mediator will pop back and forth like Samantha in Bewitched. She's in your room, all of a sudden she pops into the other room. So now I'm aging myself. But it's effective, and we can get cases done, but sometimes a Zoom mediation takes 8 or 10 hours, and maybe in person it would be 4 to 6 hours. So sometimes there's more cost involved in that.
Right. So, I think that sometimes, I think the in-person that somebody knows, oh, I got to go to court today, or, oh, I got to go to mediation today, or kind of puts a little bit of weight. Look, if I could just give up on fighting over, that one piece of china, or, the one thing, or something like that, I'm going to go to mediation. I'm going to be there all day. I got to drive. I got to find parking. I got to go to Miami. I got to do this. I got to do that. It's going to cost me a whole day and, $7,000. You know what? It's not worth it. I'll go buy another bolt from, it's not like grandma gave it to me. Grandma just bought it, for me. So I think some of that also plays a factor in the practice of law in general. I've had plenty of clients that are like, yeah, I don't want to come down for mediation. Just settle it. I'm willing to give more. Or, I'm sorry, go ahead.
Yeah, no, I was going to say part of the way that I practice and part of what I described before is I put a very high value on the cost of the fees that the client will be prospectively paying me to fight about something. So I don't like to fight about stuff. Like you gave a silly example of fighting about a piece of china. Maybe it's not silly because it's grandma's or great grandma's and it's important from that perspective. But in a lot of families, they're fighting about used furniture, used pots and pans, sheets and pillowcases, artwork that they purchased at, the home store and not at Sotheby's. And, people fighting about that, I'll often tell them, listen, just keep in mind, you're paying me a substantial amount of money. If you really want me to fight about stuff with little to no value, it's up to you, but I don't recommend it. Just get past the issue. Same thing, oftentimes more significant issues come up. Maybe there's a $5,000 dispute or a $10,000 dispute. about the way somebody used money or spent money or something along those lines. And my client will want to fight about it. And I'll say, hey, we can fight about that. And you might even win, but it's going to cost $5,000 or $10,000 to fight about it. There's no guarantee that you win. But even if you do win, you're not going to recover the attorney's fees that you spend to fight about it. So let's try to use that as leverage to negotiate the best deal for you that we can, so that we're not offsetting any gains you might have by quote unquote winning an argument or winning a claim by losing the money anyway, spending it on attorney's fees to fight about a relatively small issue.
Right. And one of the things I admire about, most family law practitioners, and you have this knack, and you even said it, you're very objective. You can look at it and you take the emotion out. How difficult is that? I know for me, just with my clients, and I don't do family law, I'm representing clients and, businesses, and they're getting sued for breach of contract and this and that. I wear it on my sleeve. I get very emotional. I mean, even this morning, I had a conversation with someone and I called my client afterwards. I'm like, how do you handle this? Like, I just wanted to jump through the phone and, I got so pissed. And you're in such a personal area, like it's personal. How do you separate that?
So sometimes it's really hard. I try to counsel my clients to not fight about stupidity. I try to counsel my clients to take reasonable and rational positions, whether it's fighting about something with the children, if they have children, or whether it's any type of a money dispute. Try not to get emotionally involved to $10,000 or $100,000. Let's look at the overall picture, and there might be 10,000 wrong over here, but you're picking up 10,000 over here, or it might be 100,000 asset over here that we're going to distribute, but you're going to pick it up in the value of the business or the cost of the house. So I really try to focus on a reasonable and rational solution to a problem, but it's not always possible. And it takes two sides to settle, and two sides are the other party and the other lawyer. And oftentimes the other lawyer and I don't practice the same way, or we don't think the same way, or the parties don't really both share a reasonable and rational perspective. Sometimes the rational and reasonable side has to make a decision for the better of both of them, or the irrational person will essentially, blow everything up, and you could spend tens of thousands of dollars fighting over non-issues just because you have an irrational person on the other side whose attorney's not telling them the same thing that I'm telling them. Don't fight about the pots and pans. Don't fight about a couple $1,000s when it's going to cost you the same or more in legal fees. So it takes two to tango, certainly, and to avoid, the emotional attachments of fighting about issues. But it's hard, and I can't say that I'm able to avoid it all the times. I think you've heard me a few times when I've been a bit explosive, but it's usually out of frustration.
And I think a lot of times when I have heard the explosiveness, it's not towards a client. It's sometimes towards, like an opposing counsel, and not angry, like, you're a dingbat or you're a dummy. It's more like, look, we're both trying to fight for the best interest of our respective clients. This phone call alone is going to cost more than the stupid plate that we're fighting over. So let's just, do it, or let's figure it out, or let's break the plate, or come up with something. And I think that's a very difficult spot. I know, in the commercial law and the business law that I practice and that I've done, it's just a tangible thing. But in your world, it's more of, it's personal, because it really is. I mean, how much more personal do you get than a divorce or something having to do with a spouse or a family member, or, you don't get much more personal than that.
Yeah, it's hard to keep the personal out of it, but you have to, especially between lawyers, you have to keep the personal out of it and focus on, as you said, the client's best interests. And, where it really gets personal in the context of family issues is if you've got allegations of child abuse or child neglect, or you have some type of allegations of domestic violence where one party is being accused or has actually physically harmed or threatened the other party with physical harm. Those are uniquely personal issues. There's no way that they're not personal. Obviously, they're addressed within the confines of the law and what we can do, but they're uniquely personal issues. If we have a a parent who is in jail because they have beat up their spouse, we know it's personal. We know what happened, and we have to deal with those personal issues, and they're very difficult to deal with.
And at that point in time, I think you have to put on your psychology type hat or your counseling type hat, and give the best advice you can. I know we're not trained psychiatrists, psychologists, but we do the best we can with what we've got. So yeah, I'm sorry. Go ahead.
No, I was going to say there's definitely an aspect of being a psychological or mental health counselor that comes with being a divorce lawyer. And I try to tell my clients when it becomes too focused on those types of things that I'm not the best person, especially at the hourly rate that I'm being paid as a lawyer. The hourly rates for mental health counselors are typically substantially less than those for lawyers, and they're typically trained to deal with them better. So I try to encourage my clients that if you just want a sounding board for your complaints and dealing with more emotional issues and not legal issues, I do try to be fair and say, I'm happy to have these conversations with you, but this isn't really my skill set, and you can save a lot of money by going to somebody who actually is trained in these types of matters.
So to all you young listeners out there who are in high school, college, and law school, get that psychiatry and sociology and every psychology, psychiatric, get all those degrees so that you can double bill. No, I'm kidding. But you can go ahead and you can counsel your clients, especially if you want to get into the family law practice. That would be some sort of good base or good sounding board. I thought I was going to be a criminal attorney. I got a criminology degree. I wanted nothing to do with criminal law. So, oh, well, no problem. So usually in this show, I ask something neat or creative or just something, a little bit out there. And I did that with one or two questions already, but you were talking about possessions and artwork and the home goods store. So for years and years, I've seen that great picture behind you. The gentleman holding the cane. What is it, and why do you have it in your office?
So years ago, I had a client who had a home goods store, which was being closed down incident to the parties' divorce because they weren't going to be able to maintain the business. So that was a painting that she had in her store, and during that case, I had gone on a family cruise to Alaska, and I have 3 children, and I have 6 nieces and nephews. So there's basically 9 grandchildren. And during that vacation on the cruise, all the kids got together, and one of my older nephews, like they kind of did this contemplative thought where they kind of put their fingers on their chins and looked up like they were thinking about something. And so all 9 of the grandkids are in this pose. And that vacation had just happened a few months before. I had gone to my client's store and I saw that painting, and I thought it was kind of classy, and it reminded me of my nieces and nephews and my children and a great time in my life. And it's turned out to be a great conversation piece since I don't have a fake Zoom background. I've had judges and mediators and parties and whoever I've been on with always ask about the thinking man behind me.
I like it. So that's the thinking man behind you. It gives them wisdom and thoughts, and as opposed
can only
to
hope.
All my distracting things behind me. So if you're thinking about divorce, if you're thinking about marriage, if you're thinking about a prenup, a postnup, taking care of grandma before she goes ahead and gets too far along in life, if you're thinking about fighting with your partners in a business dispute, and you are in Florida or can have jurisdiction of the Florida courts, because Rick, you're only licensed in Florida, correct?
That's correct. Yes. Thank you.
In Florida, call Rick Gaines, 954-603-8801, or you can get him at Richard@Gaines, Gaines, law, LAW, FL.com. And Rick, I want to thank you for giving us your time today. It's awesome. And we all appreciate you. Cece, thank you so much for putting this together. Thank you for being behind the scenes, as always, and making this a great show. I'm Jason Weiss. Check out my newly launched AskJasonWeiss.com website. That's where I'm doing my coaching, my consulting. So please reach out to me. And again, good stuff, bad stuff, marriage stuff, family stuff, call Rick.
Thanks, Jason. Thank you, Cece.